First, we've got Mr. Robert Amugboro, who is a senior advocate of Nigeria. He is the lead counsel to the APC's team, including that of the APC Caretaker Extraordinary Committee, Convention Planning Committee. And then you also do have Richard Dobry, who is the lead counsel to Delta APC officials. It's about this matter, which some of you may have seen in the dailies or read, perhaps keeping tabs as well, about the Delta State High Court, which is reported to have restrained Governor May Mala Buni, along with other members, from acting or parading themselves as APC Caretaker Extraordinary Convention Planning Committee, pending the determination of the substantive suit before the court. So, good morning, gentlemen. Thank you for joining us today on the program. Now, let me start with you, Mr. Dobry. Is that what the court actually ruled on? What is the situation?
Yes, good morning. The claimant applicants. Can you hear me?
Go ahead,
Can
please.
you hear me clearly? Yes. The claimant applicants, made up of 7 persons, approached the Delta State High Court, challenging the propriety of the World Congress that was conducted on the 31st of July 2021, and also the propriety of a proposed intended local government congress, which is slated to take place on the 4th of September 2021. In view of this, the claimants filed an ex parte application. They filed an ex parte application, and the ex parte application was supposed to take place on the 24th day of August 2021. But unfortunately, I represent the claimant applicants, and unfortunately, if I go to the court, a lawyer who was present in the court, who was not even briefed by the defendant, although he came for a separate matter entirely, saw the matter on the court stage and indicated interest to defend the defendant. And in view of that, the court adjourned the matter to the first day of September 2021 for the ex parte application to be moved. Now, in the ex parte application, the claimant applicant asked for 6 principal reliefs. 6 principal reliefs and omnibus relief, which makes it a total of 7 reliefs. Now, in the ex parte application we filed, we also attached an originating summons. We filed along the ex parte application the originating summons, which is to be sent on the defendant. Now, in our ex parte application, the reliefs we asked for, relief 1, practically days with asking the court to hear the matter on the application, which is holiday. Then relief 2, 3, and 4 has to do with issue of service, while relief 5 and 6 has to do with an order of interim injunction. Now, the very day, which is the 1st of September, the matter came up, the defendants raised an issue of jurisdiction. They raised an issue of jurisdiction, which...
All right, Mr. Dobry, before you get into that part of the issue of jurisdiction, let me equally bring in Mr. Amugboro and ask him if it's the same ruling, if that is his interpretation, before we go into all of those other parts which you are just about to highlight. Mr. Amugboro, please give us your response. Is that what your interpretation is of what the court actually ruled on?
Now I can thank you very much for having me on your program, and good morning, everybody. I do not know why my learned friend is trying to hide behind so many words a very simple question. Was there an order against the chairman and members of the APC caretaker and the extraordinary convention planning committee? The court made no such order. The only evidence of an order of court is either the proceedings, the record of the proceedings of the court itself, that's the record book, or a certified true copy of that court order. My learned friend has a copy of that certified true copy, and if he doesn't have it, that will be very sad, because the court declined to make an order restraining the chairman to members of the caretaker / extraordinary convention planning committee from acting or parading themselves as such members. The court declined to make that order. That's the 5th relief they asked for on their ex parte application. Now, on that 5th relief, there is an alternative relief, which is an order of interim injunction restraining the chairman and members of the caretaker / extraordinary convention planning committee from conducting the local government and state congresses to elect officers. The court also declined to make this order and proceeded to specifically say that the only interim order it is making is in respect of the 15th defendant. In order to properly understand the order of the court, I think I need to point out that in the originating summons filed by the claimants, there are 3 sets of defendants. The first set of defendants, even though it's not a set, is the APC itself. It is the first defendant. It is in respect of APC that I am lead counsel. Now, the second set of defendants are the chairman and members of the caretaker / extraordinary convention planning committee. They are the second to the 14th defendants. These are the second set of defendants. The third and the last set of defendants is the 15th defendant. That is Mr. Jones Irui, who is sued in his capacity as the chairman of the Delta State APC caretaker committee, executive of that state. So we have these 3 sets of defendants. Now, I need to also point out that in the ex parte application that my learned friend filed, no order was sought against APC as the first defendant. No other ex parte whatsoever on the face of his ex parte application. He didn't ask for any relief against APC. That is the party. Now, the relief that he sought for was against the second to the 14th defendants. These are the second set of defendants. That is the chairman and the members of the caretaker / extraordinary convention planning committee. Those are the only persons that even constitute the gravamen of the case that he filed, challenging their appointments on several grounds. But the court didn't make this order against the second to 14th defendants. The court declined to make the order. Now, the order the court made, yes.
Yeah. So since I mean, that's your perspective of the matter, Mr. Darby. So tell us then, how come you say the court made that order, but he's just given and read out some of the matters from the CTC, which he says is God. So could you then buttress your point with more information as to whether or not that order was made?
Are you with me?
Yes, please, go ahead.
Yes, like I said, 5 and has to do with training release the claimant applicants sought for. Now the court granted relief 5. The court granted relief 5, and relief 5 has an alternative as well. The court granted relief 5 and addressed relief 5 paragraph A. The court limited itself to the Delta State chairman, which is Odell Jones, and not the APC national chairman. Now, relief 5, the claimant asked include order of the Honorable Court stopping the Congress of the local government election is to be held on the 4th of September 2021. The paragraph A includes an order restraining the 2nd to the 15th respondent from parading themselves as chairman and critical committee. Now the court proceeded and stated that paragraph A is limited to the Delta State chairman and not me. And the national chairman of the AP has accepted that fact that the local government Congress election slated on the 4th of September 2021 with respect to Delta State is cancelled by an order of court. The national chairman itself has acknowledged that fact. The order is there.
Mr. Dalbury, let's be sure that we're on the same page here. It appears we're not singing from the same hymn sheet. First, because the CTC, it appears at least there are 2 CTCs in circulation here. So we're trying to find out which is which. So from the ruling that you have, the CTC that you have of the ruling you're citing, who was the first claimant in that particular one?
The first claimant is Elvis Asamoah, who is the deputy APC chairman of Delta State, while the first defendant is All Progressive Congress, APC. The second defendant is Marva Laduni. And the 15th defendant in question is Jones Odell.
Okay. So, but, all right, Mr. Mukoro, how about yours? Who's the first claimant in the CTC you're citing?
Thank you very much, Chamberlain. There are no 2 CTCs. My learned friend is just simply dissembling. Let him read the order he has with him. If it carries a certified true copy, they are exactly the same. You see, when he was giving his answers, he didn't claim that the order he has with him restrains the caretaker/extraordinary convention planning committee. All he said was that, the national chairman has accepted and has said that the Congress is cancelled. I don't know where he got that information from, but whatever he's saying is not reading from the order. There is just one order, there is just one certified true copy. That is why I say he's just simply dissembling. Let him read the order he has to the Nigerian public and let them be clear. I'm shocked at this kind of behavior. It is almost bordering on professional misconduct. There is an order, there is just one order from the Asaba State High Court. There is no other order circulating anywhere. Let him read what he has.
Mr. Dalbury, tell us then, which order do you have? So could you go ahead and read that then? Because it's not the same one that he is referring to. Mr. Dalbury, that's for you.
The order is the same order. My learned senior is just trying to misdirect the public. His own interpretation. Now, like I said, relief 5 clearly states When the 596, just a second, an order of interim injunction of this honorable court, restraining second defendant respondent from further
Okay,
acting.
Mr. Dabri, just hang on a minute. We need to try that connection again so that we could all hear you properly, because it's a bit woolly and not that clear. Mr. Maguire, looking through this now, because yes, we'll get him to read exactly which order he's got. But two different documents out there, and some of them, if I both have same stamps, because this CTC that you cite from also has the same name from the one that he is citing. So, and we see almost the same kind of signature. So, what's going on?
Well, I am aware of just one order, duly certified, duly paid for, with the receipt on it. And that order that I'm aware of, the interim order given by the court is expressly limited to 15th defendants. I dare say I cannot imagine my learned friend from the claimant saying that the order is directed at the second to the 14th defendants. I cannot imagine him saying so, that the order the court made is directed at the second to 14th defendant. The order is explicit, and it reads that this order affects only the 15th defendant. That is the order that the court made, limited to only the 15th defendant. And it says it is the alternative prayer 5 that is granted only in relation to the 15th defendant. Alternative prayer 5 only is granted in relation to the 15th defendant. That is the only order that court made. And if my learned friend for the claimant is saying that the court made any order against the second to the 14th defendant, then that must be a matter for the disciplinary committee of the NBA to look into. Okay, because I don't know where that order came from. I do not know where that order came from that I'm referring to.
Okay, let's do a comparison, as it were, so that we can lay this bare and ensure that there are no hidden agenda, or at least there are no misconceptions, as it were. So just to be sure this is what you have, I'm going to read the alternative 5, which I think you're referencing. It says, an order of interim injunction of this honorable court restraining the second to 14th defendants and respondents from conducting the local government and state congress slated for 4th September 2021 or any other date. To that extent, is that the same thing you have?
No, that is not the order of the courts. That is just the courts reciting the relief.
No, I'm reading the alternative. I'm reading the alternative. I'm not reading the order of the court. I just want to be sure that's the alternative you have as well.
Yes, that's the alternative relief. Yes, that is their alternative relief.
Okay, let me go on. So we are sure that first... No, I understand. We'll get there. But first, I want to go through that alternative. Then we'll now talk about what the court ordered. But let's be sure that you have the same alternative as we have here. So it goes on to say any other date and any other congress of the first defendant in Delta State, pending the hearing and determination of the motion or notice already filed and served. Is that the same thing you have?
That is the alternative relief they claimed, yes.
Okay. Now, going to the order now, which is, I think, the bone of contention.
Yeah, exactly.
So, it says reliefs. Exactly. I'm reading the other parts. Reliefs 1, 2, 3, 4, and alternative prayer 5 of the motion ex parte are hereby granted. Is that what you have?
Yes.
Okay, it goes on to say alternative prayer 5 is granted only in relation to the 15th defendant, right?
That is correct.
Good. So let's start from the reliefs 1, 2, 3, 4. Let's clear that one out, and then we'll talk about the alternative 5, which seems to be the bone of contention. So when the reliefs 1, 2, 3, 4 are granted, what does that mean? So Nigerians can understand, because I believe some people may have gotten the wrong one, perhaps some have the right one. So what does that mean first?
Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative relief they claimed, yes. Okay. That is the alternative Now the reliefs 1, 2, 3, and 4. They are what we will call preliminary reliefs. The first relief 1 is to enable this case to be heard during the court's vacation. Because ordinarily, when the court is on vacation, cases are not heard unless they fall within the remit of cases that are classified as urgent cases. But you also need the permission of the court for that case to be heard. That is relief 1. Relief 2 now relates to the 1st to 14th defendants. Since their address for service is in the FCT Abuja, the processes of the Delta State High Courts do not have the force of law outside Delta State unless there is compliance with the provisions of the Sheriffs and Civil Processes Act, which requires an endorsement to be put on that process for service outside the territorial jurisdiction of Delta State High Court. So that is what relief number 2 deals with. What they have sought for is for leave to issue and serve the objection summons on APC and the second set of defendants outside the territory of Delta State Court in the FCT High Court. That's relief number 2. Now, relief number 3 has to do with substituted service on the 2nd to 14th defendants to allow them to be served at the APC headquarters in Abuja on any staff. So they don't need to serve them personally. You can serve on any staff or any person who meets at the APC secretariat. The 4th relief is also another for substituted service on the 15th defendant, which is that it too should be served at the state secretariat. So those are the first 4 reliefs. So you see them basically, they are preliminary reliefs to deal with the issue of service and to enable the processes to be served outside the jurisdiction of the territory of Delta State.
So building up from there, just to clear that air, so at least a lot of Nigerians are on the same page with this conversation. So let's talk about the naughty alternative prayer 5, which of course has been causing a lot of controversy. So the order goes on to say alternative prayer 5 is granted only in relation to the 15th.
Can I just jump in here?
Okay, go on, please.
In order to have a proper perspective on prayer 5, you need to understand that prayer 5 has 2 legs. There are 2 reliefs claimed. There is a main relief that was claimed, and then there's an alternative relief. Now, the main relief 5 is to stop the chairman and members of the caretaker/extraordinary convention planning committee from acting or parading themselves. That is the main prayer on prayer 5. From acting or parading themselves as such members. So that's the main prayer 5. Now, the alternative to the prayer 5 is now to stop them, that is the caretaker, the chairman of the caretaker/extraordinary convention planning committee, from conducting the local government or the state congress election. So you see, the main prayer, stop acting as members of this committee. Alternatively, do not conduct this local government and state congress election. Now, the courts did not grant the main relief 5, which is to stop them from acting or parading themselves as members of this committee. That relief was clearly declined. Now, with regards to the alternative prayer, I make bold to say that alternative prayer too was declined to the extent that the court did not make an order against the chairman / members of the extraordinary convention planning committee. Because that is what they sought for in the alternative. In the alternative, they sought for an order against the 2nd to 14th defendants. The 2nd to 14th defendants are the chairman of and members of the caretaker/extraordinary convention planning committee. The court declined to make this order. The court rather proceeded, as it was empowered to make that order, that alternative order, against the 15th defendant, who is the state's caretaker chairman of the APC. Meanwhile, in the guidelines for the conduct of this Congress, the body saddled with the conduct of the Congress is the World Congress Committee, a 7-member committee who are not even parties to this case. The guideline says there shall be a 7-man World Congress Committee appointed to conduct the World Congresses. And then you also have a similar committee for the local governments and the state congresses. So these are the persons saddled with the responsibility of conducting.
Let me come in now, if I may. So how did the 15th defendant come into Alternative 5? Because Alternative 5 is quite clear. It says an order of interim injunction of this honorable court restraining the 2nd to the 14th defendant or respondent from conducting the local government and state congress slated for that date. That's what it says clearly. So the 15th defendant was not even referenced in Alternative 5. So how do you now interpret? So how do you interpret Alternative 5 in the context of the order now bringing in the 15th defendant?
You see, in the nature of any application you make to the court is empowered to make whatever order it feels will meet the justice of the case. So they did not seek for an order against the 15th defendant. They didn't seek for such an order. But the court, in its own wisdom, decided that the only party it wants to make an order against is the 15th defendant. And that is the person the order was made against by the court. The fact that you have asked for a specific relief does not mean that the court may not be able to grant you whatever relief the court feels will meet the justice of the case. Now, let me put this thing within a proper context again. It is important to understand that at the time this ex parte application was being taken, we had long filed and served a notice of preliminary objection.
Mr. Mukoro, now that particular point, it's another, okay, we'll take a look at that because, I mean, he also, in some of the arguments out there, raised concerns about those processes, which we'll talk about when we come back in just a moment. Don't go away. All right, welcome back. We've been trying to get back Mr. Richard Darby, so we'll go to him now and hope that it can or will come out clearly. So, Mr. Darby, let's hope this works this time. Well, yes, I'm sure you got quite a number of things to highlight. Having heard Mr. Mukoro say that, well, the CTC you say you're citing, it's not the right one. And if it's not the right one, it's a matter that the disciplinary committee of the NBA will have to look into. So are you telling us on authority that what you cite now is part of the records of the court? Is that the authentic CTC of the ruling you've got?
Yes, like I said, the ruling I have is the certified true copy. There's no two ruling in respect of this subject matter. We just have a single ruling, and it's a certified true copy I have. Now it depends on my learned senior's interpretation. Like I said, the relief 5 and 6 has to do with the injunctive reliefs. Now the court granted relief 5. Then proceeded and said, with respect to the issue of parody itself, it's limited to the Delta State APC chairman. That's what the court said. And the order is very clear. So I don't know why my learned senior is saying that the order is gotten from somewhere else.
So the copy, the version that you have, did you restrain the APC Caretaker Extraordinary Committee and Governor Malabuli from parading themselves
like I rightly said, with regards to the issue of parading itself, I said it's limited to the APC Delta State Chairman. But however, the fifth reading, which the claimant applicants asked for, is granted with respect to an interim injunction restraining the conduct of the election in Delta State. The Congress, in Delta State. Relief 5 is not separated. Relief 5 is a single relief.
Okay, so you're saying that, if you can hear me, so you're saying that this is just restricted to the state caretaker chairman and not the national caretaker chairman?
With respect to the issue of parading himself as the chairman of the Delta State APC.
So what about with respect to conducting the congresses?
It stopped already. By virtue of all this order, the Congress is stopped.
Can you, forgive me, I think we have to do this so we're sure that we're going through the same order. Can you read that part of the order that specifically references the fifth relief and maybe the alternative fifth relief so that we're sure? If you could read it verbatim, just to be sure.
The fifth relief stated clearly, an order of interim injunction of this honorable court restraining the 2nd to the 14th defendant respond from conducting local government and state congress slated for 4th of September 2021 or any other date and any other congress of the first defendant, which is APC, in Delta State, pending the hearing and determination of this motion on notice already filed and served.
Alternative you just read. Is that the fifth or the fifth or the alternative fifth?
The alternative fifth.
So can you read the fifth itself?
Yes, let me go through the fifth for you.
Okay.
The fifth itself.
Yes.
An order of interim injunction of this honorable court restraining the 2nd to the 14th defendant respondent from further acting or parading themselves as members of the caretaker extraordinary convention planning committee of the first defendant, which is APC itself.
That's the APC. Okay, so yes. In granting the order, what part, if you could just read it, references the fifth relief specifically, or where you reference the fifth relief, what part of the order, if you could just read it, says the fifth relief was granted?
You know, like I rightly said, the fifth relief is a single relief and it's not separated. The fifth relief.
I just want you to read. Yeah, I understand that. Just so I'm sure again that we're reading the same thing. Can you just read that part of the order that was granted eventually that speaks to the fifth relief? Are you there?
Let me proceed from here. Stated that the affidavit in support contains sufficient grounds for the grant of the release being sought. Relief 1, 2, 3, and 4, like I said, 4, has to do with issues of service. And
please go on.
Sorry?
Please go on. Go on.
Alternative prayer 5 of the motion expressed are hereby granted. Also, alternative prayer 5 is granted only in relation to the 15 defendants.
So,
in compliance with order 39. Sorry?
Pardon me. So, does it reference relief 5 or alternative 5?
Relief 5 itself.
But you just read that alternative prayer 5. That's what you just read.
Exactly.
Yes.
So that's alternative 5, not relief 5.
Like I said, the relief 5 is a single relief. The relief 5 is granted and the alternative is granted as well.
No. It doesn't say relief 5 is granted and alternative is granted. It says, and I mean, you just read it, reliefs 1, 2, 3, 4, and alternative prayer 5 of the motion ex parte are hereby granted. I don't think it speaks specifically, at least from what I see, to prayer 5, just alternative
Exactly.
5. Or am I getting it wrong?
I believe you are getting it wrong.
But it's English.
Wow.
I just well, let's take this back to the senior advocate. Am I getting it wrong? I think this is English. It says clearly alternative prayer 5 of the motion ex parte is hereby granted. It doesn't say 5. That's what the senior advocate.
It does not say 5. You are absolutely spot on. That you are absolutely spot on. That is what the order says. Alternative relief 5 of the motion ex parte are hereby granted. And there is now a qualification even to that granting of the alternative relief 5. It says alternative prayer 5 is granted only in relation to the 15th defendant. I do not know how clearer this order could have been couched. I need for my learned friend to say that prayer 5 is 1. I mean, it's mind-boggling. There is alternative means or. You have a main relief. If you cannot grant me this main relief, then you may grant me the other. The two cannot be granted together. That's an elementary principle of law. If you refuse the main relief, you may be able to grant the alternative. And the court, in granting the alternative, pinpointed that alternative 5 is granted with a qualification, i.e., its grant excludes the second to the 14th defendants.
So is it that he's taking them as though is he his own? I'm sorry. Is it that he's trying to interpret this saying, well, both relief 5 and the alternative, if you grant either or, both will be the same thing? Is that the way it's coming across? That's how he's interpreting it?
Unfortunately, I do not want to go so far as to say that the interpretation is given is preposterous. I don't want to go that far, but I mean, we are all looking at this same order. The order itself brings no any kind of ambivalence. The main relief 5 was not granted. Even the alternative relief 5 in the form in which they sought for it was not granted either. What was granted was a qualified alternative prayer 5. And the qualification removed the second to the 14th defendants. That is the chairman, stroke member, and the members of the caretaker stroke extraordinary convention planning committee from the ambit of the operation of the order. I think I also need to point out very, very importantly that even the qualified alternative relief 5 that was granted is directed at the 15th defendant not to conduct. It is not directed at the election itself. It is directed at an individual person. You, this number 15 defendant, you should not conduct the local government or the state Congress election. It is the 15th defendant that is restrained. It is the 15th defendant that can be held to violate any order. So that is directed at the 15 defendants.
Wait, if that were the case, but what they were trying to do is to ensure that they don't even conduct that election itself. So if he doesn't conduct it and somebody else conducts the election, wouldn't they have defeated, the quote unquote the rest in this matter?
Well, the order that the courts made, yes, you can apply for an order. And the court, like I said, is empowered to give whatever order it deems fit to make in all the circumstances of the case. Let me put a particular context to, I really cannot hazard a guess as to why the court decided to make the order against the 15th defendant alone. I cannot hazard a guess as to why that happened. But when you place this case within a proper context, that we are in a state high court in respect of a claim challenging the appointment by the first defendant, APC, of the second to 14th defendant. This appointment did not take place in Asaba. This appointment took place in Abuja, a place outside the territorial jurisdiction of the High Court of Delta State. That is the primary issue that is in the case. This whole case, the originating summons. Hello?
Yeah, go ahead. We can hear you. Yeah, we can hear you.
Okay. This whole case, the foundation, the gravamen of the originating summons itself is a direct challenge to the appointment of the second to the 14th defendants. This appointment was challenged on the basis of Section 183 of the Constitution, Article 17 of the APC Constitution, and decision of the neck of the first defendant, extending the tenure of this committee. So this is the crux of the case. The entire crux of this case revolves around the second to the 14th defendant and the decision of the neck of the first defendant. All of these events took place in Abuja, a place outside the territorial jurisdiction of the Delta State High Court. These are the matters
you were making a point about certain proceedings and processes, because he argued that in an ex parte matter, you cannot bring question of jurisdiction when it's not a substantive suit.
Well, I honestly do not know where that authority is from. The authorities of the Supreme Court that I'm aware of, and there are numerous of them, is basically that when a challenge to the jurisdiction of the courts has been filed and urged on the court itself, the court must be wary not to make any ex parte order or indeed any injunctive order until the issue of its jurisdiction is sorted out. Now, the general rule of law is that when you have an ex parte application, it's a one-party proceeding, i.e. only the applicant is meant to be heard. That's not really the question here.
But
the
isn't
question is when you have, yes, when you have an ex parte application.
Yeah, because in this case, if it's a 7-day application ruling, isn't the essence of that usually supposed to be in an emergency case when the matter for which they approach the court for would have been destroyed if the ex parte is not granted? Isn't that the intention?
Exactly. That is the intention, where the race will be destroyed. In this case, there is no emergency, but the court has placed the matter to be heard during the vacation. So that is no longer an issue to even be agitated anymore, in the sense that the court has said, well, I want to hear this case during vacation, it has shown sufficient urgency. So that's neither kind of that. But the point I wish to make is, when you have two applications simultaneously pending before a court, there is an ex parte for injunction, there is a notice of preliminary objection. This court, you have no power to entertain this case. You have no power to make any order in this case. What does prudence dictate? That was the points I sought to make. And there are numerous Supreme Court authorities on it. Once your jurisdiction
we're winding down
a
now,
case,
Senior Advocate.
Yes.
We're winding down on this. We'd like to get Mr. Dobry's closing thoughts. So, two issues raised. Was this a matter of emergency, really? Because that's essentially why we have, ex parte set up in the first place, so that you can preserve a matter before things go all right. So how much of an emergency was this? And secondly, if you say that really 5 is 1, vote 5 and the alternative, but still you say that the order is just for the state caretaker chairman. Don't forget, in the fifth order, not the alternative, you have even the national caretaker chairman in that. So don't you think you contradict yourself clearly when you say 5 is 1, but still you say that it's just concerning the state caretaker chairman? So if you could just take those two up in a minute or two, we'll appreciate that. That's for Mr. Dobry, by the way.
Hello?
Yes, please go ahead. Yes, we can hear you. Go ahead, please.
Yes, like my learned senior rightly said, he said the issue, the claimants or the defendants in question in this suit, some are based in Abuja, which is outside our jurisdiction. The 15th defendant in question, though appointed by the National Caretaker Committee, is resident in Asaba. Now, already Rule 4 of the High Court of Delta State Civil Procedural Rules provides all other suits may be commenced and determined in the judicial division in which the defendants reside or carries on business, in which the cause of action arose. Now, the 15th defendant, though appointed by the National, is resident in Delta State, Asaba, and carries out his function. In fact, we are not even supposed to go into the issue of jurisdiction for now, because the issue of jurisdiction is still yet to be determined by the court.
I understand so many issues. It's just about the emergency and then the contradiction around Relief 5 and the alternative. If you say they are 1, yet you choose just the other side, but yet you say they are 1, don't you contradict yourself that way?
No. It's not contradictory.
No, you said that the order just concerns the state caretaker chairman, but in the Relief 5, not the alternative, it references the national...
Now, if you clearly examine the order, relief, or the alternative relief, which has to do with the restraining order, stopping the conduct of the Congress, is in Delta State, and not the national. And that's why the court in its ruling said alternative 5A is limited to the 15th defendant. The Congress itself is not to be carried out in Abuja. The Congress itself is to be carried out in Delta State, and not in Abuja or any other state. The Congress, the claimants, applicants are challenging, has to do with a Congress slated to hold on the 4th of September 2021 in Delta State. And that is why the court limited it to the 15th defendant.
All right, gentlemen, Mr. Richard Dobry, we need to thank you. Richard Dobry is the lead counsel to the Delta APC officials, and then Mr. Robert Omukboro, senior advocate of Nigeria, who's lead counsel to the APC. Thank you, gentlemen, for talking to us today.